gentlemen, thank you so much for standing, but I think it might be a minute or two, so if you all want to have a seat, and then when the bailiff announces jurors entering, you can stand back up. We have someone who is busy.
Jurors are entering.
Good morning, ladies and gentlemen. Please remember which seat you're assigned, because that's going to be your seat for the duration of the trial. And when you find your seat, you may be seated. We stand for you.
Judge, all jurors are present and accounted for.
Okay. Madam Clerk, would you please swear in the panel?
Please stand.
Raise your right hand.
Do you solemnly swear or affirm that you will try the issues between the state of Florida and the defendant and render a true verdict according to the law and evidence? Yes. Thank you. Please be seated.
Good morning, ladies and gentlemen. You have been selected and sworn as the jury to try the case of the state of Florida versus Nikolas Cruz. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proves the aggravating factor or factors beyond a reasonable doubt against the defendant in accordance with the law that I provide you. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of our fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the lawyers. Documents and other exhibits may also be produced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the lawyers, the court, that's me, will instruct you on the law applicable to the case. After the final instructions are given, the alternate jurors will be released, and then the jury panel will retire to consider their verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all of the evidence, the arguments of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case among yourselves. So even though you are now sworn, you are now a panel, a group of people who are going to essentially be coming here and hearing the testimony and evidence each day, you may not, under any circumstances whatsoever, discuss the case among yourselves until such time as you retire to deliberate. Does everyone understand? Please answer out loud. Yes. Thank you very much. Your verdict must be based solely on the evidence or lack of evidence and the law. I now remind you and instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, no text messaging, no tweeting, blogging, or using any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of these rules at all, you must notify a court personnel of the violation so that they can notify me. So even if it is something small or something that you think may be insignificant, you have a duty to let me know by letting one of the court staff know. During the course of the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone, and I mean anyone, attempts to say anything to you or in your presence, tell the person that you are on the jury and ask the person to stop. If he or she persists, please leave that person at once and immediately report the matter to one of the court personnel who will advise me. If it's something that occurs on a weekend, you must call my office assistant, and you all have her number, and leave a message and let us know. You have to report it right away. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in court. Turned off means that the phone or other device is actually off and not on silent or vibrate. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to communicate with anyone about the case or the people involved. Do not take any photographs, video recordings, or audio recordings of the proceedings or your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room. And we will go about, I will instruct you more on your deliberations at a later time, but I will tell you now that we'll give you a contact phone number so that if you have a family emergency or some type of emergency situation, even though you can't be directly reached, you'll be able to be indirectly reached because we'll have a number with somebody standing by to answer the phone in case your loved ones or others call about an emergency, all right? This case must be tried by you only on the evidence presented during trial, in your presence, and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation on their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, or any electronic device, or any means at all to get information related to this case or the people and places involved in this case. And this applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any of the places discussed. Jurors must not have a discussion of any sort with friends or family members about the case or the people and places involved. So, do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about the case by using an electronic device. Do not send or accept messages related to the case or your jury service. Do not discuss the case or ask for advice by any means at all, including posting information on a website, chat room, or blog. Now, of course, you are permitted to tell your family members or your employers that you're serving on a jury and that you're not available, and you can even give them our schedule. But you cannot talk about anything substantive or ask for advice or discuss anything other than the fact that you're on a jury and you are not allowed to tell them anything else. The reasons for these rules are because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, I will have no way to make sure that the information you obtain is proper for consideration in this case. And the parties, likewise, will have no opportunity to dispute or challenge the accuracy of what you find. This is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity that our judicial system promises. Any juror who violates these rules jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire process to start over. As you can imagine, this is a tremendous expense and inconvenience, not only to myself and to the lawyers, but to the taxpayers. If you violate these rules, you may face certain sanctions, and I'm not even going to go into those because I know you all are going to follow the rules. Ladies and gentlemen, in every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove his innocence. From the existence of the defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that the defendant did not take the witness stand must not influence your verdict in any manner whatsoever. Now, in this case, the defendant has already pled guilty, but you cannot, if he does exercise his right to remain silent, you can't draw any inference whatsoever about his exercise of that right if that in fact happens. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections that they feel are proper. When an objection is made, you should not speculate on the reason why it's made, and likewise, when an objection is sustained or upheld by me, you may not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the lawyers outside of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such conferences may be required or how long they will take. When such conferences occur, they will be conducted so as to consume as little of your time as necessary for a fair and orderly trial of the case. Nikolas Cruz, the defendant in this case, has pled guilty to 17 counts of murder in the first degree in a previous proceeding. Your role as the jury in this case will be to determine the appropriate sentence to be imposed. The appropriate sentences for the crime of murder in the first degree is either life in prison without the possibility of parole or death. The attorneys will now have the opportunity, if they wish, to make an opening statement. An opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial, and this is the penalty phase. What the lawyers say during opening statement is not evidence, and you're not to consider it as such. After the attorneys have had the opportunity to present their opening statements, the state and the defendant may present evidence relative to the nature of the crime and the defendant's character, background, or life. You are instructed that this evidence is presented in order for you to determine, as you will be instructed, 1, whether each aggravating factor is proven beyond a reasonable doubt. 2, whether the aggravating factors found to exist beyond a reasonable doubt are sufficient to justify the imposition of the death penalty. 3, whether mitigating circumstances are proven by the greater weight of the evidence. 4, whether the aggravating factors outweigh the mitigating circumstances. And 5, whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. At the conclusion of the evidence and after the argument of counsel, you will be instructed on the law that will guide you during your deliberations. For now, I'm going to explain aggravating factors and mitigating circumstances as I have previously. An aggravating factor is a standard to guide the jury in making the choice between a verdict of life imprisonment without the possibility of parole or death. It is a statutorily enumerated circumstance that increases the gravity of a crime or the harm to a victim. You must unanimously agree that each aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your final verdict. In order to consider the death penalty as a possible penalty, you must unanimously determine that at least one aggravating factor has been proven beyond a reasonable doubt. The state has the burden to prove each aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that the aggravating factor exists. On the other hand, if, after carefully considering, comparing, and weighing all of the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proven beyond a reasonable doubt, and you must not consider it in providing your verdict on the appropriate sentence to the court. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, conflicts in the evidence, or lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find that the aggravating factor does exist. Before moving on to the mitigating circumstances, you must determine that the aggravating factor or factors are sufficient to impose a sentence of death. If you do not unanimously agree that the aggravating factor or factors are sufficient to impose death, do not move on to consider the mitigating circumstances. Mitigating circumstances. Should you find sufficient aggravating factors do exist to justify the imposition of the death penalty, it will then be your duty to determine whether the aggravating factors that you unanimously find to have been proven beyond a reasonable doubt outweigh the mitigating circumstances that you find to have been established. Unlike aggravating factors, you do not need to unanimously agree that a mitigating circumstance has been established. Rather, whether a mitigating circumstance has been established is an individual judgment by each juror. A mitigating circumstance is not limited to the facts surrounding the crime. It can be anything which might indicate that the death penalty is not appropriate for the defendant. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that reasonably may indicate that the death penalty is not an appropriate sentence in this case. A mitigating circumstance need not be proven beyond a reasonable doubt by the defendant. A mitigating circumstance need only be proven by the greater weight of the evidence, which means evidence that more likely than not tends to prove the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you may consider it established and give that evidence such weight as you determine it should receive in reaching your conclusion as to the sentence to be imposed. If you would like to take notes during trial, you may do so. On the other hand, of course, if you're not required to take notes if you don't want to. That will be left up to each juror individually. You will be provided with a notepad and pen for use, which was on your chair when you sat down. Any notes that you take will be for your personal use and must be taken only on your assigned notepad that was on your chair. However, you may not take the notepads with you from the courtroom. During recesses, the bailiff will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations, the bailiff will deliver the notes to me and I will destroy them. No one will ever read your notes, including me. We won't read them on the recesses and we won't read them at the end of the trial. They're your notes, they're for your use, and I can promise you that no one else is going to look at them. If you take notes, do not get so involved in the note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. Okay, ladies and gentlemen, at this time, both sides are going to have the opportunity to present an opening statement, and pursuant to the rules of procedure, the state goes first. State?
May we have a brief silence?
Okay. All right, state whenever you're ready.
Thank you. Good morning, ladies and gentlemen. I'm going to speak to you about the unspeakable, about this defendant's goal-directed, planned, systematic murder, mass murder of 14 children, an athletic director, a teacher, and a coach. These brutal murders occurred at Marjorie Stoneman Douglas High School in Parkland, Florida, and it happened on February the 14th, 2018. 3 days before these brutal murder, this massacre, the defendant in this case made a cell phone video on his cell phone. And this is what the defendant said. "Hello, my name is Nick. I'm going to be the next school shooter of 2018. My goal is at least 20 people with an AR-15 and some tracer rounds. It's going to be a big event. And when you see me on the news, you'll know who I am. You're all going to die. Ah, yeah, I can't wait. Ah, yeah, I can't wait. Cold, calculated, manipulative, and deadly. Now, Marjorie Stoneman Douglas High School is located at 5901 Pine Island Road in Parkland, Florida. It's bordered by Homburg Road on the north side, the Sawgrass Expressway on the south side, Pine Island Road on the east side, and on the west side is Coral Ridge Drive. But and you'll see a map, before you get to Coral Ridge Drive to the west, there's West Glades Middle School, and then a Walmart, and then there's Coral Ridge Drive. You'll see that Marjorie Stoneman High School kind of resembles a college campus. There was approximately 13 buildings spread out over the campus. Most of the buildings were 1- and 2-story buildings, except for one. The one building that is not a 1- or 2-story building is a 3-story building, and it's known as the 1200 building or the freshman building. The 1200 building is located on the northeast side of the campus. So it's bordered on the north by Homburg Road and Pine Island on the east. It's a 3-story building, and there's 2 entrances to the 1200 building. There's an entrance on the east side, and there's an entrance on the west side. And both those east and west entrances open up to the first floor hallway. The entrances are a double door on the east side and a double door on the west side. And to the right of those double doors, there's a secondary door, both on the east side and on the west side. And this secondary door leads up into the first floor landing of the stairwell. And the stairwells go up to the 3rd floor, both on the east side and on the west side. There are 10 classrooms on each floor of the 1200 building. There are 6 classrooms on the south side of the hall. There's 4 classrooms on the north side of the hall, and that holds true for the 1st floor, 2nd floor, and the 3rd floor. And Marjorie Stoneman Douglas, back on February the 14th, 2018, had a surveillance system, and there are approximately 76 cameras that spread out through the campus. And these cameras were motion activated. And what that means is they have to detect motion before they record. So if there's nothing moving, they don't record. In the 1200 building, there were 13 cameras. There were 3 cameras on the 1st floor, 3 cameras on the 2nd floor, and 3 cameras on the 3rd floor. And these cameras are installed in the ceiling. So there was a camera on the east side in the ceiling, a camera in the center in the ceiling, and a camera on the west in the ceiling, 3 cameras, and there's 3 cameras just like that in the ceilings on the 1st floor, 2nd floor, and 3rd floor. The camera on the east side, up on the ceiling, focuses west. The camera in the center of the ceiling focuses west. The camera on the west side focuses east, and that's true for the 1st floor, 2nd floor, and the 3rd floor. And there are 2 additional cameras in each stairwell. There's one on the 3rd floor of the stairwell, one on the 2nd floor of the stairwell, and that's true for the west stairwell and the east stairwell. There are 13 cameras in the 1200 building. There are no cameras in the classrooms. There are no cameras in the classrooms. And again, these cameras are motion activated. So you will see a surveillance video from the Marjorie Stoneman Douglas High School from February the 14th, 2018. You will see the defendant on the 1st floor fire a rifle, shoot and kill 9 students, the athletic director, and a coach. And the athletic director and the coach were both campus monitors. You will see the defendant fire his rifle 6 times on the 2nd floor. and you will see him shoot and kill 5 students on the 3rd floor and a teacher on the 3rd floor. You will see him wound 13 other students on the 1st floor, and you'll see him wound 3 other students on the 3rd floor and wounding of a teacher. You will not see every single second of that surveillance video. You're going to say, why? Because it's what? It's motion activated. When the defendant fired his rifle, the percussion in the hallway was so loud that it caused the ceiling tile, the dust from the ceiling tile, to fall down. And when the dust from the ceiling, and it looks like smoke, and when it comes down, it prevented the cameras from detecting some of the motion of the defendant. But most of it is there, and you will see it. The cameras are motion activated. You will also learn that because of the percussion of the defendant firing his rifle, it also affected the fire alarm system. So at 2:20, 2:38, and I'll get back to why that time is important, this fire alarm goes off because the fire alarm system was not able to detect the difference between what? Between smoke and dust. The defendant attended Marjory Stoneman Douglas High School from August the 15th, 2015 to February the 8th, 2017, and he was also a member of the JROTC. Let me take you back to Valentine's Day, February the 14th, 2018. An Uber stops in front of the east gate to Marjory Stoneman Douglas High School. It's a pedestrian gate on the east side on Pine Island Road. It's a female Uber driver. The defendant gets out of the seat, the rear seat of the Uber, I think it was a RAV4, and he gets out and he's carrying a black case and a backpack. Now, school's in session. It's Wednesday, February the 14th, 2018. It's approximately 2:19 p.m. The school starts at 7:40 a.m., Marjory Stoneman Douglas, and the last class ends at 2:40. The gates open in the morning for students to enter and go to class, and then they close. And then they open again, so right before school ends at 2:40, 20 or 30 minutes before. So what? The students can leave the campus. So it's 2:19 p.m. The defendant is carrying a black case and a backpack. And what he has in this case, is a Smith & Wesson 5.56 caliber rifle. And this rifle, it's commonly known as an AR-15. This rifle fires not only 5.56 caliber ammunition, but also fires .223 caliber ammunition. The gun will fire both. This gun is commonly known as an AR-15. It's a semi-automatic rifle. This weapon will fire as many bullets as it contains in the firearm magazine. And this is the way this 5.6 Smith & Wesson M&P 15 TF 16214 is the serial number. This is the way this gun operates. What you do is you load the firearm magazine with bullets. And the bullet is about like this for a 5.56 and a .223. And you put those bullets in the magazine, you load them in the magazine, and the bullets will go in as many as the magazine will hold. So if it's a 40-round magazine, you can stick in 40 bullets. If it's a 30-round magazine, you can stick in 30 bullets. So you fill up the magazine, and then you take the magazine and with how many bullets you have in it, and you stick it into the magazine well of the rifle. And then you pull back the lever, and you charge a bullet that goes into the firing chamber, and you pull the trigger. This weapon will fire as quickly as you can pull the trigger. And that's what the defendant had. And the Uber driver picked up the defendant to bring him to Marjory Stoneman Douglas High School from 7200 Loxahatchee Road. 72 Loxahatchee Road was the home of Kimberly and James Sneed and their son, J.T. Sneed. J.T. Sneed was a friend of the defendants. They both went to Marjory Stoneman Douglas High School together. They were both a member of the JROTC together. And a short time after Thanksgiving of 2017, the defendant came to live with the Sneeds. He had his own bedroom. He was attending school. He was working at the Dollar Tree. The Sneeds took the defendant in and offered him a place to live. Why? The defendant's adopted mother passed away November 1st, 2017. The defendant needed a place to live. The Sneeds made the offer. The defendant moved in with them. And it was a short time after Thanksgiving. These murders happened when? February the 14th, 2018. On this particular, and when the defendant arrived at Marjory Stoneman High School on Wednesday, February the 14th, 2018, he had been planning to be a school shooter long before he moved in with the Sneeds and long before his mother passed away. On this particular Wednesday, on this particular Valentine's Day, the defendant gets out of the Uber. He goes through the passenger gate. He's wearing his backpack. He's carrying his black case. It was a black Cabela bag case with a rifle in it. And he walks about 360 feet from Pine Island Road to the east entrance double doors. He walks in through the east double doors, makes an immediate right-hand turn, and walks into the bottom floor of the stairwell, of the east stairwell. He takes his rifle out of the Cabela bag, black bag, and as he's preparing his rifle to fire, in walks a student, Christopher McKenna. Christopher McKenna was a student in classroom 1216. 1216 is on the first floor. It's the second classroom from the east double door entrances. Christopher McKenna was out on the bathroom pass, and he was going up to the second floor because at the time, the first floor restrooms and the third floor restrooms were locked. And so the security could watch people go to the second floor because they were concerned about, different activities in the first floor and third floor, kids going there vaping or hiding out or whatever. So for a security measure, they did lock the bathroom doors on the first floor and the third floor. So Christopher McKenna gets a pass from his teacher. It was Miss Haas in 1216. She taught English, approximately 30 students in her class. He gets his pass, walks down the hall, bumps into a couple of kids, and you'll see the video of him bumping fists with two of the students, and he walks into the stairwell as the defendant, Nikolas Cruz, is preparing his M&P 15 rifle. And the defendant says to Christopher McKenna, "You better get out of here. Something bad is about to happen." Christopher McKenna runs out. Remember I described the secondary door that's in the stairwell? He runs out that east door, and he runs to find a campus monitor. When he runs out, the defendant enters the first floor hallway. And when he enters the first floor hallway, there are 4 students in the hallway. He gets out and he fires his weapon at the 4 students in the hallway. The time, 2:21:33. 2:21:33, the massacre begins. Here's who the 4 students were in the first floor hallway. Ashley Baez was walking west in the hallway in front of classroom 1215. And let me describe what existed on the south side. You know, there's 6 classrooms on the south side. So the first classroom on the south side is 1218. The next class, the numbers aren't, you know, consistent, but the next classroom is 1215, classroom 1215. So sitting in front of classroom 1215 is a student, Gina Montalto. And she asked permission from the teacher in 1215. By the way, it was a personalization class, so you can catch up on your homework and do different things, different from when I went to school, but you can do whatever you want in homework, whatever, like a study hall. So she asked Miss Matlock if she could go out in the hall and work on her computer because it was more private and she could get more work done on her project. Miss Matlock had offered her to go to a different classroom or somewhere else. Gina said, no, fine, I'd like to do that. So she's sitting, and when you watch the video, you'll see her legs sticking out from the front of classroom 1215. Standing next to her, knocking on the door to classroom 1215, was Martin Duque Aquillano and Luke Hoyer. Martin and Luke were coming back from, and you can get permission to go to other classes. They were coming back from somewhere near the administration building. They had to do something. And you'll see them actually coming back down the corridor and walking in. And you'll see him, Luke or Martin, bump fists with Chris McKenna. So they're standing at the door of classroom 1215 and they're knocking to get in because procedure is when class is in session, the classroom door is supposed to be locked. The defendant fires at Martin Duque Aquillano, Gina Montaldo, and Luke Hoyer. He then turns and goes over to classroom 1216. Remember I described that? That's where Christopher McKenna left from. That's Miss Ha's English class, approximately 24 students in there. He fires into 1216. You'll see on all the doors in the 1200 building, there is a glass window in the metal door. And this window is approximately 8 inches wide and 42 inches long. The defendant fired through that window, shattering the window, and shooting and killing Alex Schachter, who was sitting in his desk. The defendant then turns right outside of classroom 1216. He kneels down, he takes off his backpack, unzips his backpack, and pulls out a black tactical vest. And you'll see the vest. This vest has pouches all over it, so you can stick firearm magazines in it. There were 10 firearm magazines in that black tactical vest. The defendant kneels, takes it out, puts the vest on, takes the expended magazine out of the magazine well of the rifle, and puts in a new magazine. He stands up and he walks over to 1215 where Martin Duque and Luke Hoyer and Gina Montaldo were, and he fires into them. And then he fires into classroom 1214. Remember I said there's 1218, then there's 1215, and then there's 1214. And 1214 and 1215 are adjoining. Their doors are right next to one another. The defendant fires through the glass window and shatters it, and fires into classroom 1214. 1214 is a class that was being taught by Ivy Seamus. She was teaching Holocaust history. He fires in to 1214, and he shoots and kills Helena Ramsey. He shoots and kills Nicholas Dorette, and he wounds Samantha Grady, Samantha Fuentes, Isabel Checker, and Danielle Menescu. He then turns away from 1214 and walks back across the hall to 1216. And he fires again through the shattered window in 1216. This time, he shoots and kills Alyssa Alfadef. He shoots and kills Elena Petty. He wounds Justin Colton. He wounds William Olson. He wounds Genesis Valentin. He wounds Kishaba Magaporian. And he wounds Alexander Dorette, the brother of Nicholas Dorette, who was shot and killed across the hall in 1214. He then turns and walks away from 1216, and he's walking west. At this time, through the west double doors comes running Christopher Hickson. Christopher Hickson was a campus monitor and an athletic director. He comes running through the west doors. The defendant sees him and fires his rifle at Christopher Hickson. Christopher Hickson is hit. He's severely wounded. He falls to the ground, and he crawls over to an alcove on the north side of the first floor hallway. The defendant continues to walk west, and he's walking west. He passes Gina Montaldo, Martin Duque Aquilano, and Lou Coyer again, and he fires into them again. Then he proceeds west. Now he goes to classroom 1213. 1213 is now the third classroom from the east side. You have 1217, 1216. Remember, he fired into 1216. Now this is 1213. 1213 is a psychology class being taught by Renette Riobin. And he does, the defendant, Nikolas Cruz, does this again. He fires through that window, shatters the glass, shoots and kills 16-year-old Carmen Shentrum. He wounds Madeline Wilford. He wounds Samantha Mayer. And he wounds Benjamin Wickander. He then turns and walks west again. And as he's walking west, he passes Christopher Hickson. And you'll see it. He turns like this and shoots Christopher Hickson again. He continues to walk west, the defendant does, and he reaches the west stairwell door entrance to the stairwell. And he walks into that door, and as he walks in that door, the outside door, remember I said the secondary door, just like on the east side, on the west side, that door opens. And who is it? It's Coach Aaron Feist, who's also a campus monitor. Aaron Feist is the campus monitor that Chris McKenna ran to find to tell him about what he saw. So here's Aaron Feist opening the door. And as the defendant is walking in the first floor stairwell, he turns and he fires his rifle and shoots and kills Aaron Feist. Aaron Feist is shot twice in the chest. He falls right outside the class, that west outside door. The door closes, and he falls right outside that door. The defendant then goes up the west stairwell. And as he's going up the west stairwell, there are also, as I said, 10 classrooms on the second floor. Now, the teachers and the students, they heard the shots. And when the fire alarm goes off at 2:22:38, the procedure is to evacuate. No, they didn't evacuate. The defendant fired 70 shots on the first floor and 2 shots in the stairwell. So the teachers and students on the second floor, they heard that. So they didn't follow the procedure of evacuating when there's a fire drill. They fired the procedure that if there's an active shooter, you get away from the door and you turn off the lights and you be quiet. And that's exactly what the students and teachers on the second floor did. So when the defendant gets up on the second floor, he looks in a couple of the classrooms and he fires into classroom 1234 and 1231, shatters the windows. So there was nobody in 1234 or 1231. He he fired 6 shots on the second floor. And he goes to the east side stairwell to go up to the 3rd floor now. Now, the students and the teachers on the 3rd floor, they heard some noises, but they weren't distinct like the students and teachers heard on the 2nd floor of the shots being fired. So they didn't hear like gunfire, they didn't hear shots. But what they did, they were responding to the fire drill. So the classes empty out, they follow the procedures. Some are going to go down the west stairwell, some are going to go down the east stairwell. But when the kids are doing that and they're going down the stairwell, then they hear the gunshots on the 2nd floor. So what do? They race back up the east stairwell and the west stairwell, and they run as fast as they can to get back into their classrooms for safety. So when the defendant walks up the east stairwell, there's a teacher helping his students get into his classroom. His name was Scott Beagle. He was 35 years old, and he was teaching geography in classroom 1256. 1256 is the first classroom from the east side on the north side of the hallway. He has the door open, the kids are going in. The defendant pops out of the east stairwell door and fires into Scott Beagle 4 times, killing him. And he falls right in the entrance to his classroom. And next to Scott Beagle's classroom is 1255 on the north side. And that classroom was an English teacher, Stacy Lapel. And she's hustling all the kids to get into her classroom. And she was successful in doing that. But as she's the last one there to close the door, the defendant shoots at her and wounds her. And she closes the door and goes back into her classroom. The defendant continues to fire on the 3rd floor. He's firing from east to west. There are 2 girls, 2 students, Carol Logren and Meadow Pollock. They're in front of classroom 1249 on the south side of the hall. The defendant shoots both of them. And they fall and they go huddle into the alcove of classroom 1249. He fires and hits and wounds Kyle Lehman, Marian Kapichenko, and Anthony Borges. The other students are running away down the hall. They're running from the defendant. He shoots again, and he hits Joaquim Oliver, and Joaquim Oliver ran into the alcove of the men's restroom. Jamie Guttenberg was racing down the hall to get to the stairwell door, and she was shot. Peter Wang, he was doing the same thing. He was running to the stairwell door to run down. He was shot. The defendant then proceeded west again. And as he passes classroom 1249, just as he did on the 1st floor when he went by Gina Montaldo and Martin Duque and Luke Hoyer and Christopher Hickson, he fires into Carol Logren and Meadow Pollock as they were huddled in the alcove of 1249. He then leaves and moves further west. He looks into the alcove of the men's restroom where Joaquim Oliver was wounded. He was shot in the leg. He couldn't run. The defendant fires into and kills Joaquim Oliver. The defendant then turns and walks further down the hall. Jamie Guttenberg was able to reach the door, but she collapsed on the third floor stairwell, and that's where she died. She died on the third floor stairwell of that building. Peter Wang was shot, and he was lying in the southwest corner, right in front of the west stairwell door. The defendant walks up to him and fires into Peter Wang again. Peter Wang was shot 13 times. The defendant then looks out this little window in the stairwell on the west side. He turns and he walks over to room 1240. Now, 1240 is not a classroom. It's a teacher's lounge. And teachers go there, I guess, to papers or whatever they're doing, eat lunch, whatever. There's desks in there, and there's a men's room and a ladies' room in there, restrooms, and a couple other rooms attached once you go into the classroom, to the teacher's lounge, 1240. The defendant shoots the glass because 1240 had a glass just like all the other, other rooms, the other classrooms, 8 inches wide, 42 inches long. He shoots through that window and he goes into 1240. Now, when you go into 1240, there's a window on the south side looking over the campus, and there's a window on the west side looking over the campus. And they look over a courtyard, they look over walkways, and they look over parking lots. The defendant fires his rifle at the west window, and you'll see there's 5 bullet holes in the west window, and he fires 5 shots out of the south window. He then leaves 1240. He passes the body of Peter Wang. He opens the west stairwell door. He passes the body of Jamie Guttenberg. He takes off his vest, lays it down on the third floor landing stairwell, takes his rifle, lays it down, and he runs out. The defendant is wearing a maroon JROTC Stoneman Douglas ROTC shirt that students get when they're members of the JROTC. He's wearing black pants. He's wearing a dark blue baseball cap. He's wearing glasses. He runs down the west stairwell, and he runs down and runs out of the door, and he passes Aaron Feist. He leaves the 1200 building at 2:27:55. He started his shooting at 2:21:33. He leaves the 1200 building at 2:27:55. He runs west. Then he turns south and runs by the tennis courts. And he runs and blends in with students and teachers who were evacuating the campus. They were evacuating the campus because they heard the fire drill. When the fire alarm goes off, it goes off through the whole campus. So they were leaving. The defendant runs and gets in with the group, and they all go, this whole group of students and teachers, out to Homburg Road to the north. They pass West Glades Middle School. They go out to Homburg Road. Defendant gets to Homburg Road. He goes west. He walks to Walmart, walks through the parking lot, goes into Walmart, goes into the Subway sandwich shop that's actually in Walmart. He orders an icy. He leaves a tip, pays for it, leaves a tip, takes his icy, walks out of the Subway, sits on a bench inside Walmart, drinks his icy, there for a couple minutes, gets up, and he leaves. And he walks over to Coral Ridge Drive, and he walks south on Coral Ridge Drive, and he walks to a McDonald's on Coral Ridge Drive. He arrives at the McDonald's at 3:01 p.m. And as he walks into the McDonald's, there's a student there named John Wilford. John Wilford was a student at Marjorie Stoneman Douglas. He's sitting at one of the booths. He is the brother of Madeline Wilford, who was shot in classroom 1213. John had no idea what was going on. He certainly didn't know his sister was shot. He's calling, waiting for his mother to pick him up, as a lot of the students were, because they had evacuated. He's sitting at the booth. The defendant, Nikolas Cruz, walks up to him and sits across from him in the booth. And when you see the video, they're going to say, hey, they had to know each other. John Wilford didn't know him. And the defendant asked him for a ride. And John Wilford says, I'm not going to give you a ride. My mom's picking me up. She's going to pick me up. We can't give you a ride. So John's mom arrives in the parking lot. John gets up. He leaves McDonald's. The defendant follows him. He goes with him. He says, hey, look, can you give me a ride? He says, look, I told you, I'm not going to give you a ride. I'm going with my mom. So John gets in his mom's vehicle. They leave. The defendant crosses Coral Ridge Drive, and he walks into an area called Wyndham Lakes. It's a development. He's walking in Wyndham Lakes. And about this time, there's an officer who's responding to help other agencies. His name is Michael Leonard. He's a police officer with the Coconut Creek Police Department. And he's looking for a white male wearing a maroon JROTC Marjorie Stoneman Douglas collared shirt, polo shirt, and black pants and a dark hat. So he sees Nikolas Cruz walking on Wyndham Lake South. He pulls him over, stops him, the police come, and he's arrested. The defendant is arrested at approximately 3:40 p.m. The location is approximately a mile and an eighth from McDonald's and 2.9 miles approximately from Marjorie Stoneman Douglas. The police and the medical examiner's office, after that, arrive at Marjorie Stoneman Douglas at the 1200 building. And this is what they find. There are 14 deceased bodies at Marjorie Stoneman Douglas at the 1200 building. There are another 2 bodies at the North District Hospital. They were Gina Montaldo, the little girl who was sitting outside with her computer outside 12:15. They took her to the hospital. Gina was shot 4 times. She was 14 years old, and she died from her wounds. They also took Christopher McKenna, Christopher Hickson, the athletic director, who crawled over to the north side of the wall in that alcove. When the police came, he was still alive. They took him to the North District Hospital. Christopher Hickson, the athletic director, the campus monitor, was 49 years old. He was shot 3 times, and he died of his wounds. Martin Duque Aquillano is 14 years old. He was with Luke Hoyer, knocking on the classroom door of 12:15. When the police came, they took him out, and they took him to Homburg Road and Pine Island Road to see if they could help him. Martin Duque Aquillano was 14 years old. He was shot 8 times, and he died of his wounds. And then when the medical examiner and the police came in, they saw Luke Hoyer. He had been moved by the police so students could get out of 12:15, but Luke was still in the hallway. Luke was 15 years old. He was shot twice, and he died of his wounds. They went over to classroom 1216. It was Miss Haas' English class. Sure enough, Alex Schachter, 14 years old, was shot twice in the chest, and he died of his wounds. Alyssa Alfadef was 14 years old. She was in classroom 1216. She was shot 8 times, and she died of her wounds. Elena Petty was in classroom 1216. She was shot 4 times, and she died of her wounds. The police and medical examiners then went across the hall to 1214, Ms. Seamus's class, who was teaching Holocaust history. Helena Ramsey was shot 4 times. 17 years old, she died of her wounds. Nicholas Dorwet was shot 3 times in 1214, was shot 3 times. He was 17 years old, and he died of his wounds. And they crossed the hall to classroom 1213. In 1213, it was Carmen Chintrum. Carmen Chintrum was 16 years old, and she was shot 3 times. and she died of her wounds. They then saw Aaron Feist, and Aaron Feist was still lying just outside the west stairwell door, just to the south of the double doors to the west entrance. Aaron Feist was shot twice in the chest, and he died of his wounds. The police had brought down, before the medical examiner got there, Jamie Guttenberg from the third floor landing, and she was outside just to the north of the double doors on the west entrance. Jamie was shot one time. Jamie was 14 years old, and she died of her wounds. There was no one that was shot and killed on the second floor, but on the third floor, the police found just outside his classroom, 1216, he was moved a little bit too, was Scott Beagle. Scott Beagle was the geography teacher who was holding the door open for the students. Scott Beagle was 35 years old. He was shot 4 times, and he died of his wounds. Further down the hall, right in front of 1249, the police brought the bodies of Meadow Pollock and Carol Logren out to the middle of the hall so students could get out, after this was all over. Meadow Pollock was 18 years old. She was shot 6 times, and she died of her wounds. Carol Logren was 14 years old. She was shot 3 times, and she died of her wounds. They found Joaquin Oliver. Joaquin Oliver was the boy who was shot in the alcove of the men's restroom on the third floor. The police had pulled his body out into the middle of the hallway too. Joaquin was 17 years old. He was shot 4 times, and he died of his wounds. Just to the west, still lying there in the southwest portion of the hall, by the west stairwell door, was Peter Wang. Peter Wang was shot 13 times, and Peter died of his wounds. The BSO crime scene unit came, and they did their investigation. Here's what they found. There were 139 rounds fired in the 1200 building. There were 70 rounds fired on the first floor. There were 2 rounds fired in the west stairwell. Remember when the defendant shoots and kills Aaron Feist? There were 2 rounds there. 6 rounds were fired on the second floor, and 61 rounds were fired on the third floor. 51 rounds were found, casings were found in the third floor hallway, and 10 rounds were fired in Teacher's Lounge 1240. They found 10 casings in the back part of the bullet. That's why I'm indicating this is what they found. As I said before, when you fire a semi-automatic weapon, a semi-automatic rifle like this one, TF-16214 is the serial number, the casing pops out when another round comes into the chamber for firing, and it falls to the ground. That's how there were 17 casings on the first floor, 2 casings in the west stairwell, 6 casings on the second floor, 51 in casings in the third floor hallway, and 10 casings in the teacher's lounge. And of course, there's 5 bullet holes in the west window, and there's 5 bullet holes in the south window. They also found the weapon, the gun, the 5.56 Smith & Wesson M&P 15. It was laying on the stairwell where the defendant left it. Still had a round in the chamber, and it had a magazine in it, and still had 23 rounds in the magazine. And laying next to the gun, just as he left it, was the tactical vest. There were 5 magazines still in the pouches of the tactical vest. There was a 40-round magazine that was fully loaded with 40 rounds. And these 40 rounds, all the rounds were either 5.56 or what, .223, because the defendant's 5.56 M&P 15 fires both 5.56 and .223. So there are 40 rounds in that one 40-round magazine in the tactical vest. There were 4 30-round magazines still in the tactical vest. Three of those 4 30-round magazines were fully loaded with 30 rounds of either 5.56 or .223 ammunition. And there was the 4th 30-round magazine contained 29 rounds, not 30. They also found magazines that were changed by the defendant, discarded after he was through. On the first floor, they found a 10-round empty magazine by his backpack. Remember, knelt, took off his backpack, changed the magazine. It was an empty 10-round magazine by his backpack. In that same hallway, they found an empty 30-round magazine. And all these magazines, by the way, hold both 5.56 ammunition and .223 ammunition. They found this empty 30-round magazine. Then they found another 30-round magazine in the first floor hallway. It still had 9 rounds in it, live rounds in it. On the third floor, in the hallway, they found an empty 30-round magazine in the hallway itself. And in the teacher's lounge, 1240, they found an empty 40-round magazine, empty. This is what BSO found when they were there. You're going to see that there are 7 aggravating factors applicable to this case. And before I get into that, Judge told you about the aggravating factors in the weighing process. And remember I said it's a weighing process, it's not a counting process. So there are 7 aggravating factors for you to consider. The first one is the defendant has previously been convicted of a capital felony or a felony involving the use or threat of the use of violence. That's one aggravating factor, and I'm going to talk about each one of these aggravating factors in a little bit. The second aggravating factor was the defendant knowingly created great risk of death to many people. That's number 2. Number 3, that the first-degree murder, or in this case, murders, don't forget there's 17 sentences. So I'm talking about them as there's 1, there's 17. That the murders were especially heinous, atrocious, or cruel. 4, that the murders were cold, calculated, and premeditated. That the next one, the murders were done to disrupt or hinder a governmental function, to wit, schooling. The next one is that the victim was an appointed public official in the performance of their duties. Scott Beagle was a teacher. He was an appointed public official. Christopher Hickson was an athletic director and a campus monitor. He was an appointed public official, as was Coach Spice. He was a coach and also a campus monitor. And the last one was that the murders were committed during the course of a burglary. You're saying, burglary? Yeah, burglary. When the defendant entered that school without permission to commit an offense, to wit, murder, that's what a burglary is. And you can see that, let's take previous convictions. So, you can, even though they're not prior to February the 14th, 2018, you can consider the murder of 16 other people, even though it's contemporaneous with the one. So if you have the murder of Gina Montaldo, you can use the murders of the other 16 victims as aggravators for that, and it would go for each other murdered victim. Okay? And the 17 attempted murder in the first degree of the surviving victims, who I mentioned their names and they were shot, can aggravate each one of the sentences for the deceased murder victims. And the other felony that you can consider, that on November the 13th, 2018, 10 months after the defendant was arrested, the defendant attacked a deputy, violently struggled and fought with him, took his taser, and there's a conviction for attempted battery on a law enforcement officer with a weapon. So they are in that, under that first aggravating factor of previously been convicted. You'll see the evidence will show that there was great risk, obviously, of death to many people. That the murders, all 17, were heinous, atrocious, and cruel. All 17 were cold, calculated, and premeditated. And that to hinder and disrupt the school function, he entered the school, he shoots Scott Beagle and kills him, and Aaron Feist shoots him and kills him. The athletic director and campus monitor, Christopher Hickson, they were appointed public officials. They were killed, to disrupt and hinder the school function. So they're the aggravating factors that you can consider in this case, and I submit to you have been proven, will be proven beyond a reasonable doubt. And you'll see that these aggravating factors, and listen to, and I know you will, to all the evidence, listen as carefully as you can, and I know you will, that these aggravating factors far outweigh any mitigating circumstances. Anything about the defendant's background, anything about his childhood, anything about his schooling, anything about his mental health, anything about his therapy, anything about his care, that the aggravating factors will outweigh any mitigating circumstances. After this was all over, the police, went back and trying to do as thorough an investigation as they possibly can. They collected the defendant's backpack outside of classroom 1216. They collected this Cabela black case that he had carried his AR type rifle in. It was on the stairwell steps, on the east stairwell. And laying about 3 feet away from the Cabela bag with earbuds still attached to this phone was the defendant's cell phone. 9504-821-1107. And the police did an extraction and took all the information from the phone. There were 3 cell phone videos. And the last one, and I'd said it before, the last one was on February the 11th, 2018. Hello, my name is Nick. I'm going to be the next school shooter of 2018. My goal is at least 20 people with an AR and some tracer rounds. I think I can get it done. It's going to be a big event, and when you see me on the news, you'll know who I am. You're all going to die. I can't wait. Those words, those actions of killing 14 children, the athletic director, a coach, and a teacher, is why we're here today. Cold, calculative, manipulative, and deadly.
Thank you, State. At this time, ladies and gentlemen, we're going to take a 10-minute break. Please remember, do not discuss the case, do not begin deliberating, and again, 10-minute break, and then we'll come back into court and finish up the opening.
we bring the jury back?
Okay, you all may be seated. The jurors are present, the attorneys are present, the defendant is present. Is the defense ready to proceed?
Your Honor, at this time, the defense would reserve their opening statement until our case in chief.
Okay. Are you all ready to call your first witness, or did you plan to do that after lunch?
After lunch.
Okay. Ladies and gentlemen, we're going to have an early lunch break today. We're going to be in recess. Well, it's not that early. It's 11:52. So we're going to be in recess until 1:15. So the deputies will walk you out. Please remember not to let anyone approach you. Nobody should approach you, but if anyone approaches you and tries to talk to you, please let them know that it's not appropriate and please report it. Please do not begin deliberating or discussing anything that you've heard so far. You all are welcome to obviously socialize together, have lunch together, and you can talk about anything you want as long as it does not have to do with what goes on in here or this case. Other than that, have a nice break. If you would just please be back at 11:15, that gives you about an hour and 20 minutes. The sheriff's office will let you know exactly where they want you to report because they'll assemble you together as a group, and then they will bring you back in. And we will start with the testimony. I said, did I say 11:15? Yes. Sorry. 1:15. 1:15. That's the type of thing you can't say, by the way. So I meant 1:15, not 11:15. Okay? Thank you so much. have been excused and we are in recess. We're gonna start at 1:30, but we're gonna follow the schedule. It's broken down to what happens at 1:15, 1:20, 1:25, only because it's a big job to get the jurors in and out and coordinate in that back hallway. So you all should have a copy of the schedule. I'd like to start promptly at 1:30. Thank you. We're in recess.